Hi, I'm Steve Boehm, head of the capital markets and investment teams at Evershed Sutherland, and I'm delighted today to be speaking with an old friend and a current regulator, Caroline Crenshaw, a commissioner at the SEC. Caroline has had an amazing career for the few years she's been on Earth. She started as an associate at what was then Sutherland, Aspel and Brennan, where, by the way, we never lost a championship game on the softball field, and we thank her for that legacy. Caroline left us to go to the office of what was then the Office of Compliance, Inspections, and Examinations at the SEC. She then moved on to the Division of Investment Management, which makes her uniquely qualified to discuss issues of interest to this group. After that, she went into the Army. She decided to serve her country and became a member of the Judge Advocate General's Corps, and today holds the rank of captain in the Army Reserve. So we salute her for that. After that, she spent time on the executive staff working for two commissioners. And after that, she made a mercurial rise to be a commissioner herself. I'm not aware in the history of the SEC if there were too many people who rose from a staff position like that to being a commissioner. So we're thrilled to have Caroline here today. Thank you for being with us.
Well, thank you, Steve, for that really kind introduction. And it's lovely to see a familiar face, even if it's from an electronic distance. And I do recall some of the early BDC roundtables that took place in Washington when I was a junior associate. And the event and the industry really have evolved since that time. So I really appreciate the opportunity to speak today. And I'll just add before we go on that the views I express today are my own and do not necessarily reflect the views of the commissioner and staff. And with that, I'm really excited to be here and look forward to your questions.
Great. And I'll just underscore something that Caroline said. She truly is one of the few folks who sat on the commission who know something about BDCs and not just the initials. So another reason we're thrilled to have her here. Caroline, a lot of the folks who are watching this video have spent time dealing with the SEC staff or have had their counsel dealing with the SEC staff, and they have an idea what IM does. What does a commissioner do on a daily basis?
So every day is obviously different, and for better or worse, a lot of days still include peering into a webcam, much like I am doing at the moment. Hopefully soon we'll be all back in person and maybe out of this sort of strange hybrid world. But generally, my team includes five folks, each of whom has expertise and job responsibilities that really align with the SEC's mission. And their skill sets and their background really round out my own background. And they're all just critical to the functioning of my office. And I'll say one of the first thing I look at a team when I'm hiring is really just the collegiality and making sure that everyone on the team fits and can work together. So that's my daily interactions are mainly working with those five folks. But as you're likely aware, we're pretty busy. We have a pretty intense agenda at the moment. And so as we get through that agenda, there are times when I'm directly involved. So rulemakings, for example, or enforcement matters, where I'm voting at an open commission meeting or a closed commission meeting. And then there's times that the staff take action pursuant to one of a series of rules that grant the staff what's called delegated authority, or the ability to act, on behalf of the commission. And that's sort of, for example, routine exemptive relief, or staff no action positions, although, the exact authorities for each of these are a bit different. And as you can probably imagine, individual commissioners can't realistically handle the tremendous amount of volume that require commission action. So that's why this series of rules was developed to define when staff can act versus when the commission action is needed. And so with that being said, with the commission staff taking on a whole lot of work of the agency, on a regular basis, I'm really spending time on the enforcement calendar, on rulemakings, on meeting with the division heads, division and office heads and directors to make sure I'm understanding the various developments and emerging issues, to understand what the staff is working on. I also have an open door policy, so I meet with anyone who asks to meet with me. And that includes all types of folks, different organizations, different types of businesses, different affiliations, different ideological leanings. And so it might not be right away, but eventually, I meet with everybody, but I have a pretty heavy meeting schedule given that policy. And then, we're monitoring corporate disclosures and announcements and activities, just as all of you are. And then last, I'll just add responding to real-time events as necessary. Obviously, there's a current event going on right now that we're paying attention to over in Russia and the Ukraine. Things like meme stocks. So real-time events are things that we have to pay attention to as they unfold. So that's, again, just a variety of what my schedule looks like on any given day.
Well, thank you. That's actually very enlightening. And I assume your 5-member staff includes 2 counsel who help you deal with the substantive issues. I know that was the case when I was on the executive staff.
I have 4 counsels now. I think
Oh my
Dodd-Frank
goodness.
expanded the number of counsels we're allowed to have.
Oh my goodness, I could have used that help way back when. So let me ask you this. How often, one of the things that has come up in the BDC space over the years, because it's such a unique area and because there were so many issues that really weren't contemplated by the statute or were contemplated and the world has changed since they were contemplated, how often, if at all, do you deal with the Hill on issues, whether BDC or not? Because there are issues that have come over the years from the Hill to the Commission.
We have at the agency, we have a Leg Affairs office whose job it is to really work with the Hill. That being said, as a presidential appointee and Senate confirmed, there's certainly some dialogue I have with the Hill on a variety of issues, whatever it might be, whether it's something that I am particularly interested in or something they are interested in that they want my view on. So we talk to the Hill, I would say, fairly frequently, but Leg Affairs really is the sort of sole responsibility at the agency for talking to the Hill and providing technical assistance on bills.
Now, I know IM is a very technical area, and thank goodness you have some background, which gives, I think, the industry a lot of comfort, because frankly, there has not been a history on the Commission of folks with investment management background. There have been a few, but it hasn't been that often, so that we take great comfort in that. In that regard, how often do IM issues, other than rulemaking, or including rulemaking, come by the commissioners, and which are the issues that have been of particular importance that people really dug into in the recent past?
So pretty frequently. Obviously, IM is an incredibly important agenda. I meet with the director and his team regularly. His counsels are regularly in touch with my team, keeping them updated. So it's hard to say specifically, but we have a number of rulemakings in the IM space. We've been working on a number of rulemakings in the IM space. So I have one counsel dedicated solely to IM issues. So it's a full-time job to work on IM issues. And that person unfortunately gets other stuff too, so more than a full-time job on her plate. But it is a full-time job dealing with investment management issues. I don't know if that answers your questions. If you want me to go into
It does. No, that's very helpful and very comforting to know that there's that kind of focus. Because again, oftentimes on the commission level over the years, the IM has gotten short shrift, and it's great to know that there's that kind of focus. In that regard, what's been the most interesting or thought about or important, if you will, issue that's come across from IM to the commissioners in the recent past? What have you really had to think about? What have you really had to talk to IM about to really get comfortable?
So I think it's been a very busy agenda. I'll say I think there's 3 examples of issues that I think are particularly of interest to this audience. And I'll say one is the valuation rule. The valuation rule has a compliance date of, I think, fall 2022, if I'm not mistaken.
Right.
You probably know the
That's
answer
right.
to that. And so many people in the industry are focused on the implementation of Rule 2A5. But it's my understanding here, and again, you can correct me if you have a different view, but I think from my perspective, the rule probably did not and is not going to create major waves in the BDC space. It does seem to me that the processes and procedures developed over time to value really the largely illiquid BDC assets, for the most part, align with the rules. So that's sort of my impression with that. But I'm sure there might be a different take at the roundtable. I think another area of focus is the cyber proposal that we put out recently, that we proposed February. I think it was in February. It applies to RICs, RIAs, and BDCs. And it, high level requires all registered advisors and funds to design and implement cybersecurity policies and procedures, essentially to be prepared for future cyber threats. That's high level. I can go into more details. And then there's reporting requirements. So the proposal would require a regulatory reporting of any significant cybersecurity incidents to the commission within 48 hours. And that's one piece of the cyber puzzle. We also proposed rules for corporate issuers in this space, which include 8K filing requirements. And we've asked for comment on those. So look forward to your thoughts and your comments in terms of, should these include BDCs or publicly traded investment advisors? And we really look forward to your thoughts on that. And I think lastly, I'll just mention the private funds rule. Our recent rule proposal really assesses and then proposes reforms to the markets in which private funds advisors operate. And I think the reason behind this, as I mentioned in my statement, was that these markets are often opaque and present a variety of investor protection concerns. And while I think probably most aspects of the proposal are not directly applicable to BDCs, I think there are a couple of important takeaways for BDC managers here, just regarding increasing transparency to investors and assessing some systemic risk questions. So just for example, my statement, when we proposed the rule, noted that disclosure alone in the private fund space and other areas really might not be sufficient for investor protection, because we've seen private fund advisor structure deal to benefit advisor at the expense of the private fund and its investors, or charge fees for services the advisor never really intended to provide, and that sort of thing. So I would just want to put that on folks' radar as something that I am certainly thinking about.
I'll just go back to your first point, and it's going to be part of the discussion at this roundtable, or has been already, and that is, I think in the BDC world, given how hard BDCs and their service providers have worked at valuation and the use of third parties, other than perhaps changes in the way board resolutions are drafted in connection with valuation, I think most of what that rule contemplates is already being done in the BDC space. But that's, we'll see what people have to say about that conference. But I do feel that it's not a major change to BDCs. So we agree on that. I think one thing participants in this conference are anxious to hear, and probably the most important thing from your perspective, is how, if at all, commissioners or the commission as a whole views BDCs. As I mentioned earlier, BDCs from your time with Sutherland at the time, and I know you have some views. But we'd love to know what the commission thinks about BDCs when BDC issues come before them. Probably not that often. What are they thinking? And the reason the question is somewhat interesting, I think, is because unlike any other aspect of the 1940 Act, all of which is designed for investor protection, what's in the public interest, etc., the legislation for BDCs tells us that not only are they being regulated in the same way that other 40 Act companies are, to wit, in the best interests of shareholders and for the protection of the public, but also there's a policy underlying them to provide capital to small and growing businesses. So there's a balance there. And I'm wondering how, if at all, the commission thinks about BDCs.
Absolutely. So I can speak for myself, not the whole commission, but I can certainly talk to what I'm thinking about when I'm thinking about BDCs. And I think they form a small part of the asset management industry, but really an important and rapidly growing piece of the investment company space. And I know that they keep several of my colleagues very busy, some of whom I think you're going to be hearing from at this conference, who really spend a significant amount of their time on BDC issues. And I think BDCs are unique because, as you noted, Congress established them for the purpose of making capital more readily available. And so I think some of the reasons BDCs are appealing are that BDCs can give investors exposure to private equity or venture capital-like investments they ordinarily may not be able to access. At the same time, the regulatory disclosure requirements allow investors greater visibility into a BDC's capital structure, their financial information, and their portfolio composition. And I think it's my understanding BDCs also may offer attractive dividend yields and certain tax efficiencies. So I think those are all really interesting aspects of BDCs. In addition, they form a really, I think, a unique point at the intersection of many of our regulatory regimes that we work with daily. The Investment Company Act, the 33 Act, with the exception of privately offered BDCs, the 34, the Securities Exchange Act. I might have listed those and gotten their acronyms wrong. The Investment Company
You
Act,
got it.
the 33 Act, the
You got
34
it.
Act.
You got it.
You know, but I think, and there's certain things that make BDCs different from regulated funds. Fees, unlike regulated funds, BDCs can pay performance fees to their external investment advisors. The share issuance below NAV, I think that's a really interesting piece. Obviously, all of you know this, but unlike regulated funds, BDCs with their annual shareholder approval are permitted to sell shares below NAV and may issue longer warrants, options, or rights at an exercise price below NAV. So these are really interesting features. Another which I'll just mention is leverage. And I think, as you all know, in 2018, Congress modified the asset coverage requirements applicable to BDCs to permit BDCs to use leverage at approximately double the level permitted for other funds. So with that in mind, there's certainly some risk areas that I think about when I'm thinking of BDCs in my capacity as a commissioner. And one really is just the nature of BDC investments, right? These are illiquid securities issued by small or financially troubled businesses. And when coupled with greater leverage and perhaps other built-in incentives to make risky or higher yielding investments, that certainly is something I want to keep in mind, and that it could translate into investor losses if we're not careful, that really could be sudden and extreme. And I think we saw some of that during the financial crisis of 2008, although some of the items I mentioned above, I mentioned on purpose because I think some of those may have alleviated some of those losses in the 2020 market turmoil. But that's certainly something I'm continuing to think about. And the last thing I'll just mention is the nature of the relationship of fees in the structure of BDCs. So as you all know, fundamental to the 1940 Act are protections against self-dealing and overreaching by advisors and other affiliates. So, for example, we want to make sure a BDC isn't being used to prop up a portfolio company in which another advisory client may have an investment. And we want to make sure investments really are made solely for investment purposes and not to generate transaction-based compensation or other fees for the advisors or their affiliates. So I think for me, disclosure of fees and expenses is paramount. And a BDC's investors must be able to make an informed decision if the advisor or its affiliate is generating additional compensation from the BDC investments. So that was a long-winded answer to your question of how I think about BDCs.
Well, that's great, and it reinforces the comfort we have in knowing that there's a voice on the commission that's aware of the BDC industry and has such a great understanding of the issues. I'll mention that although this is your testimony and I'm the questioner, I will mention for the commission's benefit that we're seeing more and more structures related to what people are calling the democratization of private equity. So you can expect, I think, a rise in BDCs that are not debt oriented. We're hearing from a number of folks who want to do equity BDCs, and they'll have their own interesting questions. So I'm doing that as a be prepared because those are coming your way
All
soon.
right.
So that's again, thank you for having that kind of background. How should we think about the fact that? Let me take a step back. We were all waiting anxiously for a new division director in IM because a lot of things get clogged before there's someone who can do an ultimate sign-off. We're very pleased that the commission has gone ahead and appointed a new director. Interestingly, and I don't think he's the first, I think he's the second, pure academic, although he did start his career at a law firm, that the new director is an academic, and which brings a whole different perspective, we think, to the regulation of investment companies. What's the commission's thinking in bringing in an academic, and how do you feel it will impact, if at all, the way the division operates?
Certainly. So William Bird Thistle was appointed as IM director, I think, in December of 2021, right at the end of the year. And he was previously serving as a professor, as you noted. And I will just start by saying he is a fantastic director of the Division of Investment Management. He is thoughtful, he's knowledgeable, he's collegial, and I've really enjoyed getting to know him and his deep understanding of the issues in the investment management space. And I think it's really interesting, and I think you alluded to sort of some perspective about academics here, and I suspect maybe I'd challenge you to think a little bit differently about the role of academics. I think one of the interesting aspects of academics, having worked for one, having worked for Commissioner Jackson, who is an academic, is academics are steeped in data. And I really think it benefits everyone to have regulation that is evidence-based. Looking at the data, looking at how we can use the data to best inform our analyses. And Director Bird Thistle and the extraordinarily capable staff in the Division of Investment Management really, I think, are working together to build appropriate and balanced policies that promote the health of the asset management industry and balances the investor protection mission. And in doing so, I think they're listening to the data in a way that perhaps is really maybe not different than ever before, but I think with a perspective of an academic who's really thinking about big questions and not necessarily focused on the, exactly what is the tradition or what is the way we've done it before or what is the answer. It may not mean it's different, but we're using the data to, I really think, make informed policies.
That's encouraging because I think there was, usually when there's a division director coming in, we know that person because they came from the staff, or we know that person because he or she came from the industry. Very encouraging to hear the positive news. One thing I would mention, and I don't know if this gets to the commission because it's usually done at the staff level, but one thing that the division has been doing, and we encourage it, and it should be encouraged from the highest levels, is they've speeded up some processes. They've cut the 120-day minimum or maximum time for comments on exemptive applications to 90 days. They've decided that in some cases they're going to give expedited review if an application is exactly on all fours with another application. They've been interpreting that narrowly, but it's there, which is terrific. Anything that the commission could do, and this is not a question, it's a statement. There's no pressure. So we encourage that kind of thing, and I know obviously it's a function of staffing. There's only so many things that so many people can do, but we think that's a very good development, and we would just encourage that and encourage the commission to encourage that to the extent personnel allow that. Let me turn the page a little bit and ask you about your experience in the Office of Compliance, Inspections, and Examinations, which is now the division. Is it Division of Examinations today? And what was the thinking about changing that office, if you will, to a division level status?
I'll get to a real answer in a minute, but I think no one could ever figure out where the ands and the commas went.
Very true.
Was it Office of
Very true.
and Inspections Examinations? Was it Compliance Inspections and Examinations? Was it Compliance, comma, Inspections, comma, and Examinations? I think
Guilty.
let me tell you, when I did my business card when I first got there, that was a challenge for me. But no, in all seriousness, I think it was renamed the Division of Exams. I think at the end of 2020, December of 2020, which was right around the 25th anniversary of OC's creation. And I know you have some colleagues that were absolutely instrumental in getting it off the ground and running. And since that time, it's really just grown in both number of employees and percentage of SEC employees. And I think, divisions really are bigger than offices. And so now I think it represents, if I'm not mistaken, the second largest office or division at the SEC, behind the Division of Enforcement, because their mission is really, really vast. All of our registrants. So they have broker-dealers, they have the IAIC component, investment advisor, investment company. They have the exchanges, they have the clearinghouses, they have FINRA, they have, their mandate really is vast. And so in those past 25 years, to cover that, they've developed really a strong program with staff located not just in DC, but all of our 11 regional offices. And I think now the name just really reflects the important role that the truly exceptional staff in exams, I'm going to say OC, in exams play in support of our mission to protect investors and really just be the boots on the ground, also informing our rulemaking, our policies, and how we need to update or not, as the case may be, the various regulatory rules and agendas of the commission.
Any exam issues now? Obviously, the examiners and the inspectors, if we still have any, the examiners report to their heads in that division, and they interact regularly with other divisions. Technical issues, they'll interact with market reg. I guess it's now trading in markets and investment management. You see how old I am? I still call it market reg. Do issues arising from exams specifically ever get to the commission level? I wouldn't think they do unless they result in enforcement actions. Or do you have contact with that division?
So I have regular contact with the division, and I would say the most frequent division of exams work that comes to the commission are the risk alerts. So the risk alerts that go out that are providing updates on what they're really seeing more real time than perhaps the other divisions, to provide advice or guidance or insight into what they're seeing in the markets. Those come to the commission. So I look at all the investor alerts that come out of OC. Exams. I'm going to do it probably until the end of my time. That come out of exams. And so that for me is really helpful as they're thinking about what to do in terms of risk alerts, what's going to be most helpful to industry. But I do meet with the director regularly as well. I have a individual on my team that handles the OC issues. And so there are regular issues that come up to the commission, but the most frequent are going to be the risk alerts and the priorities that they put out at really the beginning of every year, letting folks know what they're going to be focused on in terms of priorities.
The priorities is what the industry looks for each year. Because obviously we try to get compliant in every way, but obviously you're going to focus most on what the examiners are focusing on. So that does get to the commission level. That's interesting. That's interesting. And the division director, what is his or her background?
So we have Dan Call, who's in the division right now. His background is investment management, actually. So he was in the Division of Investment Management and came over to exams as their chief counsel. And then when the prior director, Pete Driscoll, left, Dan Call took over as acting director. And so his background really is private funds.
Oh, that's interesting. And should let everybody know if they have private funds, they need to be very, very wise and sage in the way they comply, because obviously he understands it in a way most people at the commission frankly don't.
He is very well.
So that's insightful. I'll leave you with one last question, and that is, what right now is, other than Ukraine, what is the biggest single issue at the commission, regardless of division, at the commission level?
Oh gosh, that's a hard question. That's a really hard question. For me, I don't know that I could answer with just one. I'm really not sure I can. Obviously, the issue in Ukraine is one we're paying close attention to. I would say Cyber is an issue that for me is always top of mind. And it's something that certainly keeps me up at night. I want to make sure that everyone has the processes and procedures in place to, do what they can in case of a cyber attack. Obviously, one that's been getting a lot of recent news coverage is climate, a rule that is coming out of the Division of Corporation Finance, and what we're going to propose there. So that's certainly one that's getting a lot of attention. And so I think those are two for me, but the market structure issues are important. And then I certainly can't leave crypto off the table. That's certainly an issue that I think I personally am spending a very significant amount of time on understanding, trying to think through the best ways to help ensure a compliant crypto regime.
Well, that's great. That is very insightful and I think useful for our audience. And I think we're out of time. I want to thank you, Commissioner Crenshaw, if I may call you Commissioner Crenshaw,
You can call me.
for your time and your insights. And we look forward to hearing what you're doing on the commission level and continuing the great work you and your staff are doing. So thank you so much for your time.
Thank you. It's really great to be here, and I hope I will always be Caroline to you.